Sakshi, mana Sakshi. Welcome to Sakshi Reddy Special Immigration Show with Attorney MS Prashanthi Reddy from Law Offices of Prashanthi Reddy, PLLC. Please note that Sakshi TV now has 3 immigration shows every week. On Tuesday at 3 p.m. EST with Attorney Ms. Sheila Murthy, and Wednesday at 5:30 p.m. EST with Attorney Ms. Prashanthi Reddy in English, and on Friday at 6 p.m. EST with Bhanu Ilendra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for the use of this information. If you need special legal advice, please contact the attorney directly. So, without any further delay, let's start our show. Hello, Prashanthi ma'am. How are you? And welcome to our show.
Hello, thank you.
Today's our topic is how to increase chances of H1 approval, F1 to H1 issues, and QA on H1b cap. Ma'am, how do we know that we will fit into this H1b visa?
Basically, in order to plan to do the H1, we pretty much should be out of the planning stage right now and in the implementation stage, because March 9th is when the registration opens up, and that's in a few days from now. So you should have already given, if you are an employee, you should have already given your information to your employer. If you're an employer, you should already have registered. You can start registering on March 2nd. You should have already registered in the USCIS website as a H1B registrant, and you have to have all the information handy, such as your name of your company, the address, the beneficiaries information, and whether you're filing under masters or H1B cap. So all that information you should keep ready, so that as soon as the registration opens up on March 9th, you'll be able to file your H1B registration without any further delay. And once you file your registration, you will know by the end of March whether your registration has been picked or not. And then once it's picked, if it is picked, then you will have 90 days to actually file your H1. So in order to file the actual H1, because today our topic is not so much about registration, because we have already covered that in our previous episodes, but we're talking about how to actually file the H1. And in order to file the H1, the information that you need to have ready is, if you're an employer again, what job you have for your employee. Is it with a client? Is it with a third party? If it's a third party, then you have to have your purchase order and your agreement, proof of job basically ready. And in addition to that, you also need to have your employees' documents ready, such as their degree copy. If they're in masters, then their master's degree copy and all the other educational credentials. Everything has to be ready. And in addition to that, you also need the employment contracts, passport copy, proof of their actual status. If they're in the US, that means their I-94 or I-797. So these are some of the basic documents that you need to have ready in order to file your H1.
Thank you, ma'am. And now we have a caller, Rajkumar. Rajkumar, can you please go ahead?
Yeah, hi, Prashanthi.
Hi.
I have a question. Hi, on H1 cap. So we had a candidate who got his H1 approved, picked up in the lottery, and he's in India. So he's fixed the schedule with the counselor for the counselor interview, which is in the next week. But recently I heard that there's some circular that there are some restrictions for traveling to US until March 31st for people who have got their H1 picked up last year. So I would like to know if this person can attend this interview next week, or should it be postponed to April?
That's a great question, because I don't think we have that in our list of questions, but that's a great question, and especially important for people filing their H1 this year, 2021 cap. Simply because, yes, there is a presidential proclamation which is set to expire on March 31st, if it is not extended, that is. then yes, if that person will have to reschedule their appointment for after March 31st, or you should fall within one of the exceptions. There are many, many exceptions to the presidential proclamation. And one of them, and also there is a court case. So the US Chambers of Commerce has filed a court case against this executive order and they won. But unfortunately, the scope of the case is only for members of the US Chambers of Commerce. So if your company is registered as a member, then you automatically fall within one of the exceptions and you can go ahead and your employee can go ahead and attend the interview even before March 31st. If you're not, or you're not able to take registration now before the interview, then they have to wait until after March 31st. And even then, it's possible only if the proclamation doesn't get extended. Because the Biden administration has um, basically restricted or has removed the other parts of the proclamation with reference to green cards and the family-based immigration, but they have kept this non-immigrant petition part of the proclamation alive. So we're hoping they won't extend it. They are looking into it. But as of now, yeah, either you need to become, you either need to um, fall under one of the exceptions, and the most important one is being a member of that US Chambers of Commerce, or you need to postpone the interview for after March 31st and see how it goes with the proclamation.
Thank you, ma'am. And we have one more caller online, Shubham. Shubham, can you please go ahead with your question?
Hey, ma'am. My question is related to H1 transfer. So wasn't sure if it's the appropriate question for this call.
Sure, no problem. Any question is a good question.
Okay. So actually, the scenario is like my H1 was filed last year and it got approved. And the processing which it followed was consular processing instead of change of status, right? So my question is, since there is a temporary ban on the stamping till 31st March, so is it possible, like, I could change my employer without getting stamped, or I'll have to wait for the stamp to change my employer?
So if you filed a transfer, but for some reason they were not able to approve the, you're not in status, or they thought that you were not in status, that's why they didn't approve the transfer with an I-94? They only approved it with consular processing, is that what happened?
So initially they filed for just the consular processing. So the transfer, I want to ask that question, like, can I look for new jobs right now? Or I cannot do that? That's my question.
Okay, so first we have to find out what is your status presently. First you have to tell me what is your present status. Sorry?
So my status currently is OPT.
Okay, so you filed an OPT and you filed H1 under cap, not a transfer. You filed a H1b cap petition, correct?
Right,
Okay, so when you use the word transfer, it means something else. That's why I was confused. But if you filed a H1b cap petition and it was approved for consular processing, if you continue to be in F1 status, then you can file another H1 under the present cap because you're still subject to the cap because you never actually worked on a H1. Now, the strictest interpretation of who is cap subject and who is cap exempt basically is that unless you worked, it's not enough to just get a H1B approval consular processing. To be exempt, you have to have actually worked on the H1 in order to be exempt. That's the strictest way that USCIS has been interpreting cap exempt cases recently, which means that you have to file now under the March, when March 9th comes, you have to file for your registration and file for your application under this cap. Now, if you want instead to use the previous H1 that you had, you are not subject to the presidential proclamation because unless you were out of the country last year. If you were on an F1 status last year as well and you were in the country when the proclamation came out in the summer, then you are not subject to the cap. It is only for people who are outside the country that the proclamation applies. So it doesn't apply to everyone. So first see if it applies to you or not. And if it doesn't apply to you, then you can go to the consulate. As long as the consulates are open for business, you can go to the consulate and get a visa. But if you don't want to do that for some reason, then yes, you have to apply under this cap, the coming cap.
And we have one more caller online.
Hello.
Hello, Amita. Yes, please go ahead with your question.
Yeah, hi, ma'am. My name is Amita. I'm currently in the US on H4 visa, and I've been looking out for H1b sponsorship so that I can resume my career. Our consultancy has agreed to file H1b for me in exchange of the security deposit and the entire H1b processing fees. So I would just like to know if this is advisable to go ahead with me paying the H1b process fees and getting my H1b sponsored.
Yes, so my dear, this is not allowed by law. The employer is not supposed to be taking a fee from you to file the H1. So if it's not allowed by the employer, your case also could, from the employer's point of view, your case also could get jeopardized, and your status also could get jeopardized. So I suggest you follow the law and you don't do what is not allowed. There is no such thing as employer taking a security deposit. He's not allowed to. And also he's supposed to pay the fee, the 1,500 portion of it at least. I mean, it's debatable. You could maybe pay the premium processing part of the fee, but with reference to the 1,500, 750 part of the fee, there are different sections in the fee. So that part by law he's supposed to pay. Whoever, he or she, the employer is supposed to pay. So my suggestion is not to go with an employer that is and there has to be a job available. So you can't just file in return for, some security deposit or whatever like that is. There has to be an actual job available. It has to be a bona fide filing, and everything has to be as per law. So I suggest that you follow what the law says.
Okay, thank you, ma'am.
You're welcome.
So, ma'am, we have another caller online. Suresh, can you please go ahead with your question?
Yeah, sure. Hello, ma'am. This is Suresh from Charlotte. So my question is that my H1B got approved in October 2019. Before that, I was on F1, and since then I'm working in States here as a contractor, and now I have to go for my stamping to India. So I was just confused between this due to this proclamation that should I check with my employer that we are going to be exempt from it if in case it get extended after this March 31st.
Right. Always check with a lawyer or your employer. Ask them to check with a lawyer to make sure that you are actually exempt. But as I said, if you're physically present in the US at the time of the proclamation, you are exempt anyway. It is only for those people who have never been to the US and are filing a first time, H1, and they're outside the country and they're filing, the employers are filing for them, prospective employers are filing for them. They are subject to this whole proclamation. So just explain your situation to an attorney or your employer, whatever it is. If you are subject to it, then you look into what are the exceptions, and then you see what kind of exceptions there are, and see if if your employer is a member of the Chamber of Commerce, or there are many other exceptions actually. Healthcare exceptions are there, national interest exceptions are there. So you have to go through it's a very big proclamation and the exceptions are many. So you have to go through each one and see which one you fall under, provided you are subject to the proclamation in the first place, and then give a written explanation of how you fall under an exception or how you're not subject to the proclamation, and then go to the consulate well prepared. That's my suggestion.
Hello, Prashanthi. How are you?
Hi, Dan. Nice to see you again.
Welcome back. And, I know you guys have been talking a little bit. I jumped in, but then I don't know when you guys were cut off. But then I would like to go back into the prominence of, just like the last year and the years before, what is that, this March 5th, sorry, the March 9th, the registration process date, which runs into the March 25th. Now, what is the prominence between March 9th and the 25th? If you can just reiterate a little bit back to our viewers. I've been seeing a lot of messages, so I just wanted to recover the topic as well.
Right. So just March 9th and March 25th is significant because that's the time that you can actually register. This year there's a pre-registration process whereby you first register on the USCIS website. And once you register, and there's some basic information that's needed, company information, beneficiaries information, passport number, name, whether it's under bachelor's cap, master's cap, etc. And once you register, they will have a lottery based on those applications that they receive, which is online. And then they will actually do the lottery based on those applications, and they will let us know by April 1st whether you're picked in the lottery or not. And once the registration is picked, they will send something that looks like a receipt, and then they will tell you where to file and how much time you have to file, and you have to follow the instructions. It's 90 days to file once you get that receipt.
Okay, we'll come right back to the registration process, but we do have a caller, Kirti from California. Kirti, you're on the air. Please ask your question.
Yeah, sure.
Hello?
Thank you for the opportunity. Hello, ma'am. I have a question on H4 processing. I'm currently on H1 status, which is expiring on mid of May. And I have filed my H4 along with my husband H1 extension last month. So my question is here, looking at the H4 EAD delay processing, I'm thinking to go India and get it stamped, but my case is change of status. So if I do that, my existing EAD process can I still continue, or do I have to file again?
So since it's an extension, it's only when you file a change of status and then you leave the country that the change of status application actually goes away. I mean, if you leave the country, then the change of status of application gets denied. But since you're filing an extension, your EAD remains current, and once you leave the country and come back on a fresh H4, and that's a good question, by the way, because it's a little tricky. Once you leave the country and if you're able to come back on a H4, then I think that your EAD application should continue, because you have the I-94. You have proof that you have an I-94, and nothing happens with your H4 extension status. It goes on as is, really. So even if they send an RFE on your 765 saying that you left the country and the I-9 send us a copy of the latest I-94, you can send that to them and they should be able to continue processing your EAD application.
Okay, yeah, that's because I heard differently previously, so I thought I'll check with proper lawyer and then get confirmation that there shouldn't be an issue on my EAD, because my whole intention is to fasten the EAD.
Right, but just remember that when you leave, you don't know when you're going to get an appointment, because consulates are not really functioning full forces yet. So you need to make sure that, this doesn't actually lengthen the process instead of decrease the process. So just make sure. And, USCIS may not actually know that you left and came back, and they may continue processing the H4 EAD as is, and there might continue to be a delay on your H4 EAD. So what I'm saying is, leaving and coming back will help you with reference to your H4 status, but it may not help you with reference to your H4 EAD application, because the delay for the H4 EAD is not due to the delay in H4 processing. It's EADs itself are being delayed.
Even the biometrics appointments,
yes.
It's a big issue.
Yeah, everything is with reference to EAD is being delayed, and it's not necessarily something H4, even after the H4 approval comes, the H4 EAD is still being delayed.
Okay.
That's something to think about before you decide to leave and come back.
Well, thank you, Kirti, for that call. But then I think you need more a personal legal advice here. So If you'd like to set up a consultation with Ms. Prashanthi Reddy, she can be reached at area code 212-354-1010, or you can email her at prashanthi@reddyesq.com or visit them at reddyesq.com. Before we continue the topic, I think we are now getting bombarded with calls. We have Ajay from Chicago. Ajay, you're on the air. Please ask your question.
Hi, thank you.
Thank you.
My question is related to EB2 to EB1. Is this a right time to ask that question, or should I call back?
Absolutely.
Absolutely.
Okay. Okay. So I have been with the married employer since 2004, like 16 years, and then I came to US in 2012. And last year my H1 extension got rejected, so I went back to India and I came back in the month of November after consular processing. And so now I am looking to change. So I already have 140 approved on EB2. So because I am leaving to planning to leave the company, my employer is saying that they will upgrade EB2 to EB1. And I came to US on SOC code 151121. So I'm really not sure, like, is it applicable, like, can it be done or not? So I wanted your suggestion on that, like.
So employers can say anything, but you have to check whether you qualify for EB1. Not everyone qualifies for EB1, right? That's why it's extraordinary ability or exceptional ability or whatever it might be. They have that tag in front of it, right? It's not just ability. So you have to be somebody that's extraordinary, or you have to be a multinational executive. So not everyone qualifies for EB1. So even though your employer wants to file because they want to retain you, it may not be possible. So you need to fall under one of those categories in order to file. If you're simply a software engineer, then unless you're exceptional, you may not fall under that category. So you may not qualify for EB1. So remember, either you have to have some kind of an exceptional ability, or you should be a multinational executive, which pretty much means, L1 category. Even if you're not on an L1, if you have come into the country or intend to come into the country as a executive position, then you qualify for EB1. So these are the ways that you can qualify.
Okay, yeah, thank you.
Okay. All right, Ajay, I hope she answered your question. But then when he was talking about the SOC code, I think this whole session today is about how to get an H1b approval if they're picked in the lottery. Now, this swings back into, I do have something in mind where, now what's happening with these SOC codes? They might have changed, but then the computer programmer 151251 and the 151299 computer occupations, all other, and including the level 1 wages, to apply the H1Bs. Has there been any change at all? I've read something that they're putting the computer programmers back. Does it apply to computer occupations, all other, and including the level 1 wage LCS? Can you throw some light on this, please?
Yeah, and again, good question, because this is again very relevant to the H1B cap. One of the ways to avoid an RFE or to improve your chances of getting an approval is to obviously select the proper category. If you're starting off with something that doesn't qualify, no matter what you do after that, you're not going to be successful in getting an approval. So it's very important to do proper research into which categories are specialty occupation and which are not, and what the current trends are with USCIS, because that keeps changing, as we know. Facts are not facts. What USCIS says is a fact, but otherwise it's not. So it's a little weird that way, the situation. So as Dan was asking, yes, there was a recent memo whereby it rescinded a previous memo which disqualified computer programmers from the specialty occupation category, which means that, yes, you can file as a computer programmer, but you still have to prove that it's a specialty occupation, but at least they're not going to outright reject it. They will look into, like any other job title that you use, they will look into the actual job, they'll look into the duties, and they, will see, they'll try to understand whether it requires a bachelor's degree in a specific field or not. So I think we're in a better position where computer programmers are concerned, than we were before. But I would still be a little hesitant to use it. But there's a huge advantage in using computer programmer, systems analyst, programmer analyst, all this category of titles, which are a little lower than the software engineer title, which is usually being used now, simply
I mean,
because the salary is lower.
okay, so that's what I wanted to ask. Is it because the wage levels are lower, or you think based on your experience all these 20 years, is it something to do with the entire process of establishing the trying to demonstrate the specialty occupation?
Yeah, so they're trying what they did, I mean, under the previous administration, they were trying to remove low level or lesser paying jobs and only promote jobs that have a higher salary. That's pretty much, anti-immigration kind of agenda that they were promoting. It's not that program analysts were paid lesser amount of money. It was less compared to a software engineer, for example. So there is a huge advantage in using those job titles which we haven't been using from the last 8 years maybe. So yeah, definitely if you have to, based on the salary, if you have an employee that you're not paying that much salary, and if the job is actually not of a software engineer, but it's more, close to being a program analyst or a systems analyst or a business analyst, right? You can't just put everything under software engineer simply because it's more approvable. Because then they'll question and they'll say the duties are not, you're saying it's a software engineer position, but the duties look completely different from a software engineer. So you can't push everything into that category. So there are instances when you have to file, these different other categories. So I would say I'd be, more willing to use those titles and give it a shot than before. I would just say maybe that, look, you're wasting your time maybe. But now I will definitely think that there's a good chance of approval. Also, it depends on the duties and every case is different. But yeah, I would say if you need to go ahead and use those titles. With reference to level 1, level 2, level 3 wages, so depending on what salary you're paying, if you have to use level 1, I would say use it. I would suggest that if you can bump up the salary to level 2, my suggestion is to use level 2, but if you absolutely cannot, then I would say use level 1. We've had issue with level 1 salaries 2 years ago in 2019, and now that issue has pretty much gone away because attorneys and AILA were able to show that, their emphasis on level 1, and they were saying that if it's level 1, it's not a specialty occupation. We were able to show that it is against the law, what they're saying, but still, nothing to prevent them from sending an RFE. So, that might raise a red flag, they might send an RFE, but yes, there's enough information out there to respond to such an RFE. So I would suggest using level 2, but if you can't, yeah, go ahead and use level 1.
Okay, that explains that. But then I have someone sending me a question here, as opposed to when we're talking about the, I really want to get into the nitty-gritties of the collection of documentation, the key elements to get that approval if they're picked in the lottery, the registration process. Now, one question someone's had here, he had an H1b picked in the lottery last year with the random or the registration process. The start date on the H1b was October 15th. Now, the USCIS has accepted the application. It was sent in time. They collected the fees. And after a couple of months, they sent out a notice. They have closed the case because the start date was not October 1st. Is there a way to rehandle this? Because I'm sure, they have sent the application within 6 months, since the applications were not sent out on April 1st, as it was in, previous years. Now, is there a way around for the employers, the petitioners, or the beneficiaries to work around this if they've had a rejection after 6 months, if they were, filed in regular processing and waiting for such a long time?
Yeah, another good question, because this is something to avoid. Though USCIS is wrong here in rejecting those cases. So basically what they did last year is, if you put you're supposed to put a start date of October 1st or later. It's not October 1st. It's October 1st or later. That's the law, because you can't file a petition. The fiscal year starts on October 1st. So obviously, you can only start working on October 1st. Therefore, you need to put a start date of October 1st. But there's nothing that's preventing you from putting a start date after October 1st. And we've always done this, November 1st, December 1st, depending on when the employer wants them to start, really. But this year, again, I mean, like last year, because under Trump's administration, everything got really strict and they were using the most narrow interpretation possible, they rejected so many cases um, of people that filed with the start date of, after October 1st. And so there's litigation again. So if you have a case, there is litigation that's going on right now. AILA has been sending out emails. If you want to be part of the litigation, you can join if you're an employer. And it's a very good case because they're really what they're doing is against the law. But again, who wants to fight with USCIS? So always follow the easiest path forward. So this year, make sure you put October 1st as the start date. No matter what, if until this whole issue is resolved. So that's another important tip. Then put October 1st as the start date, even for cases. And this is the weird part. October 1st was not put as the start date, and a later date was put, most attorneys, because they were filing under the second cap. And October 1st was already over, right? Because the second cap started in November sometime. So obviously they put a current start date. How can you put a backdated? The date is already over. How can the employment start on that date? So that was the reason why a later date was put in most of these cases. But anyway, now my suggestion is for all those employers out there, make sure whether it's the first pick or the second pick, until it's resolved, put October 1st as a start date.
Okay. So I'd like to jump into the key elements, irrespective of their changing status, they're coming from overseas, from countries like India. Now, what are the key elements from the employer's perspective, as well as the employee, the beneficiary, the future prospective employee? What are the major documents? I know there are, passports, educational certifications, educational documents and certifications, but then what are the key elements? They can sending out a fail-proof application, so it goes in, gets approved and comes back. If they're consulting, working through a third-party staffing company, do they still need these client letters to establish that employer-employee relationship, or has anything changed at all?
So I think the three key elements for a H1, one is specialty occupation. That is basic thing. You have to show that the job itself qualifies under a specialty occupation, right? And the way you show that is by making sure that you put in and explain the duties properly. People often just copy and paste from somewhere the duties from ONET, and it's just a vague, very high-level description of duties. So go into as much detail as you can. Make sure you highlight the sophistication of the duties, because that will be in your benefit. So first key element is the duties, and make sure you construct the duties properly. The other thing is, now the beneficiary has to qualify for the position, right? The position might require a bachelor's in computer science. Does the beneficiary actually have that? So you have the next key element is the educational documents and the evaluation if required. If it's a foreign degree or if it's a tricky degree, if you're combining education and experience, then it's essential to have an evaluation. So that's another important element to avoid an RFE. A certain RFE is these are the essential elements, is the evaluation and the degree copies, obviously. The third key element, if they're in the US, is proof of their status. Are they in status or not? So the I-94 is definitely a key document to submit. So I think these are the three key elements. And the fourth one I would say is there a job available for the beneficiary, especially if it's an IT consulting type situation? They will always give more importance to that type of H1 when it's a consulting, whether a job is available. In other situations, other kind of jobs, maybe they won't give it that much relevance, but in the IT scenario, is there a job available is a big question mark. So in that scenario, then you'll have to submit some kind of an agreement or a purchase order or a client letter for that purpose. So yes, a client letter can still be useful in two ways. One is to show that a job is actually available, and the other is to enumerate the duties. So the duties, they want them to come from the horse's mouth. If they're working at the client side, then they want the client manager to say what the duties are rather than the consulting companies to enumerate the duties. So client letter is important in that aspect, but it's not important in the right to control aspect. Like we've had 60% of RFEs last year were right to control. At least we don't have that now. But yes, client letter is still important.
we've been talking about the H1b, the approvals, how you can get an approval in the new cap, which is opening up March 9th. We've had a lot of insights. If you have missed any part of this, you can rewind on YouTube. We stream on YouTube. If you can go to other platforms and see if you can if you can watch any catch up. But if you can't find it, we will definitely post a copy of this video, upload by within 24 hours. You could go to facebook.com/Sakshi TV USA, or you can visit the parent YouTube page, search for Sakshi TV News, and you can watch this episode once again. So Prashanthi, let's jump into the F1, the most popular F1, where a lot of students, I know, you and I know, they have a 20,000 extra visas allocated every year. My first question here, with the 80,000, I think it's 59,800 plus the 20,000, close to about 80,000 visas. Has there been any change with this number?
Yes, and that's something that we were hoping to see, but the present administration obviously has its hands full, and a lot of advocacy groups, H1b advocacy groups, are disappointed with the present bill that was presented by Biden, because though it talks about many important elements, such as green card visa numbers, which is extremely important, and getting illegal people status and other things, it doesn't touch upon the H1b numbers at all, or increasing the H1b numbers, which has been a sore point among industries, companies. They have been pushing hard to increase the number of H1s. But it seems like, even though earlier the Republicans were more amenable to increase in H1b numbers, now with COVID and everything, there seems to be a perception that the voters may not want to see an increase in the H1b numbers. So it's become a little controversial compared to previous. So otherwise it would have been great if it was included in the comprehensive immigration bill, because this is a comprehensive reform, and there's been no comprehensive reform since the 80s. Immigration and Nationality Act is from the 80s. So we were hoping to see something, but we haven't. But we've also heard that there will be piecemeal legislation, and everything will be cut up into different pieces, and maybe H1b reform will be part of that legislation. So we really have to wait and see right now. But as of this year, is basically only 85,000.
Okay, so for the students now, as we all know, most of the students, their applications are being filed by the staffing and consulting companies. Now, before we get into more details, what is that, as let's talk about dummies who have not done this before, and there have been a lot of new companies who have set up shops, and specifically like consulting businesses. I've heard there are hundreds of thousands of companies being registered every year. Now, when they are picking a student, it is a possibility that the students are filing multiple duplicate applications from different employers. It could be for the same project, it could be for a different project. So can you just get into these basics of the nuances to explain what happens and what is that they have in terms of enforcement, in terms of the regulations, what is on top of the list?
So yeah, so we're basically here talking about duplicate filings. And duplicate filings have never been allowed, even before this registration process started, even from the last many years. USCIS has always said that employers, of course, cannot file more than one H1B cap, one H1 for one employer, because then they're using up, one employer can just use up 10 numbers by filing 10 different cases for the same employee. So that is not possible at all. You cannot do it. If you do it, then both your cases will get denied. But there are further nuances to this. So while one employee can have two employers filing for them, that is allowed. They've allowed that. So that is not considered to be a duplicate filing. But it is considered to be duplicate filing if those two employers are filing for the same job. So say he's working at Wells Fargo or something like that, and two different employers, ABC and XYZ, are filing for that same project, then that is considered to be a duplicate filing. And if you do that,
I just want to add something here. This is very funny to note, but then I'd definitely like to have some expert focus on this. I've been reading on a lot of Facebook groups, WhatsApp groups. Companies have been posting, specifically the staffing businesses, they've been posting as, hey, are you on an OPT or you're on a CPT and you have a project, we will help you find the second H1B on the same project. Now, I'm assuming they're thinking if it doesn't get picked in the lottery with the other employer, they can take over. So, but aren't they abusing the system by just pushing in applications for, what if the same beneficiary went to 5 different employers and said, just put me into the registration system. Now, as opposed to 80,000 individuals, we have only 20,000 people, duplicating the whole system into 80,000 applications. So what is your take on this?
yeah,
Is there
so
a way, this can be changed, or, the government
the
is
problem, Dan, is I'm sympathetic to those students as well. For employees, it's a business, so it's as simple as that. But for those students, I don't blame them for filing 3 petitions, 2 petitions, 4 petitions, because their status is at stake, and there are a lot of people who have filed continuously from the last 3 years, and they haven't gotten the H1, right? So at some point they've finished their CPT, they've done their 3rd masters, they have done 3rd masters CPT, they've been going for the last 7 years, they've been on, there are many people like that, and they haven't been picked in the cap. So I think the system it's a wrong system. When there's so much demand and there is no supply, the answer is you have to increase the number of H1B caps, right? But to your point that if there is a law, the law has to be enforced, and it is being enforced to the extent that, yes, so if you file 2 H1s, 2 different companies, same project, and if both get picked, and if both file, then both will get denied because you're using the same PO, right? So that student should be careful. It doesn't mean that you file, you use the system to max it out, then you will be at a loss because both your H1s will get denied. And that has happened for me last year in one case, because we didn't know that he filed through another employer, and both filed and both used the same PO, both cases got denied. Then the beneficiary came to the employer and said, oh, why did this happen? He was like, because that's the law. But there is a loophole in this system, as you know, because in the H1B registration, they're not asking for all this information. They're not asking to produce the information about the job.
It's a pretty simple application. But before we jump into more info on this, we have another Ajay from, this time I think he's from North Carolina. Ajay, you're on the air. Please ask your question.
Hello, ma'am. I have a question. For a job requirement, my company is sending me to India to work for some time. I already I-140 approved. So after going to India, my question is, my H1 also expiring pretty soon. So can they extend when I'm in India? And second question is, can I also change my job when I'm in India and to another employer? Means
So
H4
you have
transfer and
to,
H4 extension both.
so you have to remember
H1
this.
transfer and H1 extension. Mm-hmm.
So you have to remember this. When you're in India, the immigration laws in the US don't apply to you. So you're not on a H1, you're not on an extension, you're not on a transfer, you're not on anything. You're in India, right? So you're not under any status in the US. So you can of course work from India for your US company. You have to figure out what the tax implications are and how they'll pay you, etc. But if you want to change jobs, so you basically have to file a fresh H1. You will be cap exempt because you were previously on a H1, and you have to file for H1 consular processing because you're outside the country, and then get a visa and come back in. That's the way to change jobs.
That's okay, but I can also do an H1 transfer to another employer, right? A new probable employer also can file H1 transfer, right?
They can
That's
file a
an
H1,
I-140
but they will
private
file,
employer.
yes, but they can only file a H1 for consular processing because you're outside the country. They cannot file a transfer. You will not get an I-94. So you have to go to the consulate, get a visa and come in. Yes, you can do it, but it's not called a transfer. A transfer is
Yeah,
when
that's
you're in the US and you're filing for a change of employers. That's called a transfer. So you have to file consular processing.
so the employer does
Okay.
change doesn't make any difference here. I just have to go to consular processing, right?
Yes,
Once
correct.
approved. Okay.
Yes.
So
Okay.
also,
Okay, Ajay, thanks for that call. I hope your question is answered now. Um, Before we continue with the conversation, if you'd like to seek services for the H1B registration process, as well as filing the H1B cap petitions, if you're an employer or an employee, you can reach out to law offices of Prashanthi Reddy at Prashanthi with an H at reddyesq.com, or you can call them at 212-354-1010. I'm sure she has the bandwidth to accept more applications. You know, she's been here almost a year now, answering questions. I don't say crazy questions because I know these are very legal in nature. I'd like to reassert: don't get those answers for your immigration from WhatsApp groups and Facebook groups. If you're talking to somebody like you're going to make it worse. You're going to get into trouble. You should always reach out to a qualified professional attorney like Prashanthi Reddy to get answers. Now, we have only 5 or 7 minutes left, but I still have another caller. I would like to take this call. Shaker from the sunny California. Shaker, how you doing? You're on the air. Please ask your question.
Yeah, hi. Thank you for the opportunity. My question is, I have a EAD through EB2 to EB3 downgrade EAD, and then if I go out, I think what I learned is it's better to be on H1b stamping even though I have a EAD in place. If for some reason if I am not able to get the H1 stamping, if I come to the US on EAD status, can I switch back to H1B?
Yes, so if you leave the country, there are two ways of coming back. You can either come back on your H1 visa, as you just said, or if you have your advance parole approval, you can come back on your, if you don't have a visa, you can come back on your advance parole as well. Now, if you come back on your H1, of course, it's a no-brainer, you will continue on H1 status. But a lot of people have this question: if they come back on advance parole, instead of coming back on H1, do they still maintain H1 status? And the answer is yes. This is an exception to the general rule that if you come back on a particular status, that becomes your status. In this particular case, if you come back on advance parole, you can still maintain your H1B status. It's very important to note that, because sometimes when your visa expires, you may not want to go again and risk getting another visa. So you can just come back on advance parole and then continue as usual on H1. But if you change and start working on an EAD, if you change your I-9 form and start working on an EAD, then you cannot switch back to a H1. It's only advance parole use that allows you to continue on a H1, but not the EAD use. That's important to note.
All right. Thank you, Shaker. Thanks for that call. If you need more help, you could give them a call at 212-354-1010. Now, I'd like to jump. The time is a constraint now, but we can definitely continue in our next session. Keep watching us every Wednesday at 5:30 p.m. Eastern Time. But then I'd like to really ask you about the beneficiaries who have CPTs, who were unfortunate that their H1Bs were not picked in the lottery. They moved from OPT to STEM OPT. Then, they joined the colleges back with new programs. Now, I've heard a lot of them, they either get denials or they get an approval with the consular processing. Now, what is that they can do to get rid of this problem in its entirety?
Don't use CPT. But yeah, I mean, yes, whenever you file a change of status from F to H, there is a standard RFE that comes for not everyone, but for a lot of people. And they generally ask for proof of status during your entire CPT period, your entire OPT period, if you had previous masters in that period. So they want to show proof of status. So basically, it's a big topic to cover, but just briefly, CPT they usually have issues because they're working and they're living in a different place and they're attending university in a different state. So always the question is, how are you attending university which is 100 miles away when you're working, in a different state?
But would it
So it's
offset with
always
the
the question.
COVID-19 last year? Is there any offset with the COVID-19 because everything was virtual and remote?
Yes, obviously that was easier for us to respond because we could say that, look, he's working and studying in the same state because he's from home. He's doing everything from home basically, studying as well as working. So yeah, it was easier to respond, but they were still sending out those RFEs. But what generally the way we respond is we show that usually they have an executive program whereby they go on the weekends. So it's important to show how they're commuting, what bus or plane they're taking, air tickets, if they're staying in a hotel, on site, university site, those expenses, hotel expenses, travel expenses. So that's how we usually show that they're actually attending in-person classes.
But in your opinion, is it legally still accepted that they have a full-time 40 hours of CPT? CPTs are usually what I understand they're only part-time, but a lot of universities who approve a full-time 40-hour CPT. How does that really, is that legal?
So the way they do that is through via this executive program. So they have classes on Friday, Saturday, and Sunday, full time, all day, whole day classes, and they make up for their in-person course requirement in those 3 days, and that's how they do it. So the rest of the days they're working, and they have Friday evening classes. So obviously it's allowed. That's how they have the CVIS and they have permission to do it. Uh, but yes, it results in a lot of RFEs, and there are ways of avoiding that by providing proper documentation in the outset, and we can discuss that in the next program, go into more detail on CPT.
All right. Thank you, Prashanthi. We are completely out of time, but you have given a lot of insights today. But keep watching us every Wednesday at 5:30 p.m. Eastern Time, and we will jump into more topics. If you would like to give us a call, you can also post questions on our Facebook page. If you want to reach out to the attorney for a private consultation for your H1b cases, this is for both the employers and beneficiaries who are waiting. And if you have any other questions, not just related to H1B, if you need assistance with other applications like the green cards, perms, and 140s, please give them a call at 212-354-1010 and email them at prashanthi@reddyesq.com. Thank you, Prashanthi. It was wonderful talking to you, and we'll see you soon again.
Thank you.
చూస్తూనే ఉండండి తెలుగువారి మనస్సాక్షి సాక్షి.